The U.S. Supreme Court is hearing arguments in a high-stakes lawsuit brought by Mexico against American gun manufacturers. The Mexican government claims that negligent practices by firearm companies fuel cartel violence by allowing weapons to flow across the border. The gun makers argue that U.S. law shields them from liability. This case could have major legal and diplomatic implications, potentially redefining how gun manufacturers are held accountable for crimes committed outside the United States.
Indeed, if Mexico is right, then every law enforcement organization in America has missed the largest criminal conspiracy in history, operating right under their nose, and Budweiser is liable for every accident caused by underage drinkers, since it knows that teenagers will buy beer, drive drunk, and crash. The First Circuit gravely erred in embracing that implausible theory and should be reversed.
Mexico's complaint pleads that petitioners aided and abetted violations of specific federal gun laws and that those violations proximately caused Mexico's harm. That satisfies PLACA's predicate exception. First, the complaint details that petitioners deliberately supply the illegal Mexican market by selling guns through the small number of dealers that they know sell a large number of crime guns and who repeatedly sell in bulk to the cartel traffickers.
Pues a cualquier porque entonces, como ya reconoció.
The theory is that your client under example 2, has aided and abetted as the manufacturer. Proximate cause doesn't appear in that portion of the statute. It's only in the predicate portion. So if we accept that framing of the theory, the framing of the complaint, we're really only asking about proximate cause, as Justice Gorsuch was asking you, between the retailer, the sale, and the harm ultimately caused to Mexico. And then we're looking at the chain of events that you're talking at right now. Sale to the bad guy, smuggled across the border, misuse.
So I think I have two responses, Your Honor. The first is I actually disagree with how you framed it, but the second is even if I accept how you framed it, I still think there's no proximate cause. The statute says that there has to be proximate cause between our violation and Mexico's injury. Our violation is not the illegal sale itself. It's the actions that we undertake to aid and abet it, the violative aiding and abetting conduct.
Mexico's lawsuit has nothing to do with the Second Amendment or with the legal rights of law-abiding Americans to buy and possess firearms. This is not what this case is about. Our concern is the illicit trafficking of guns into our country, where their possession is illegal, as a consequence of the negligence of gun manufacturers who are very well aware of their diversion. We look forward to hearing the decision of the Supreme Court of the United States, and we will continue to do everything we can to protect our people from the violence and suffering caused by guns trafficked into Mexico.